1 minute, less than 1 minute. All right, looks like it's about noon, and we're going to get started with this CLE today. We have Auditing Scoresheets is effective assistance of counsel. This is Florida Bar approved, a 1 hour CLE at the intermediate level, and that's your approval period. And it is good for 1 credit hour general and 1 technology. I tried to get couple more, but they wouldn't let me get away with any bias elimination on this one, so that'll be on the next one. I'm your facilitator, Alvin Wellington Barlow, out of Jacksonville, Florida. And an overview of our CLE today is we'll give you a presenter's background, the law, the facts, how to audit score sheets. And I know that's like pulling teeth for criminal defense attorneys. I remember that when I used to do it. Deploying technology, ESAS service, we'll get into that. And ABA criminal justice standards. This is a real sleeper right here. I know most lawyers, probably 95% of the lawyers don't know about it. Q&A, and we're going to offer an anonymous electronic survey. It will be emailed when you send an email to request the CLE credit. We will not put the course number on this video. But those who complete it, you'll get that email at the end, and you can send an email confirming that you've watched the CLE, and I will personally send you that information. Here's my information. I started out my practice of law as a certified Florida Supreme Court certified legal intern in the state attorney office in Jacksonville, Florida, back in the summer of 1985. That's my mugshot. I still have my badge from back then. And then I went to work at the public defender's office. I was assistant PD. And by the way, I tell people this all the time, that's the best job I ever had. The pay was lousy, but the work was great. We did a lot of great things for a lot of good people. And so I was there from 1986 to 1988. Been in a private practice ever since. I'm blessed to be in the Georgia bar since 1994 and the Florida bar since 1986. The law, Florida's Constitution, Article 1, Declaration of Rights, Section 2, Basic Rights. All natural persons, female and male alike, are equal before the law and have inalienable rights, among which are the right to enjoy and to defend life, liberty, and to pursue happiness. We've heard that before. We're going to show you how to manifest it in the law today. No person shall be deprived of any right because of race, religion, national origin, or physical disability. Florida Statute 921.002 is the criminal punishment code, and the code shall apply to all felony offenses except capital, that should be capital, offenses committed on or after October 1st, 1998. The criminal punishment code embodies the principles that A, sentencing is neutral with respect to race, gender, and social and economic status. That's a quote right from the statute, and that is aspirational. As we know, it's not necessarily practiced. The primary purpose of sentencing is to punish the offender. Rehabilitation is a desired goal of the criminal justice system, but it's subordinate to the goal of punishment. I have to highlight that because we get reminded of that all the time with the sentences that we get for our clients. The penalty imposed is commensurate with the severity of the primary offense and the circumstances surrounding the primary offense. Now, that's when you get into proportionality. And that, a lot of times we're focused on equity and inequity, but sometimes we forget about proportionality. Proportionality is persons guilty, but they don't deserve to be excessively punished for some offense. So you're fighting on two fronts: equitable sentencing, which is fair, and then the proportionality of the sentence in relation to the nature of the offense itself. Inequity gets into, how it is, what sentences are being given in relation to what sentences have been given out to other people who are similarly situated. So the severity of the sentence increases with the length and the nature of the offendant's prior record, of course. And so the sentence imposed by the sentencing judge reflects the length of actual time to be served, shortened only by the application of incentive and meritorious gain time as provided by law. It may not be shortened if the defendant would subsequently serve less than 85% of his or her term of imprisonment provided by the statute. I cannot tell you how many people still do not know that, there's not the kind of gain time that we used to get, that they used to get back in the 70s and early 80s. I was just talking to someone this year I'm working on a case for them, and they didn't know that, this is not a lawyer now, didn't know that you have to serve 85% of the sentence. And they were still talking about parole. Parole ended with the start of the CPC. Departures below the lowest permissible sentence established by the code must be articulated in writing by the trial court judge and made only when circumstances or factors reasonably justify the mitigation of the sentence. The level of proof necessary to establish facts that support a departure from the lowest permissible sentence is the preponderance of the evidence. And the good thing about that statute is it is not exhaustive. That list is not exhaustive. If you can find any rational basis that a judge can articulate or express in writing for a basis for a downward departure, and I'm arguing, and I hope the law changes to support this position, I'm arguing that proportionality in relation to the nature of the offense, as well as the inequitable sentences that are given out to similar people. Let me give you an example of what I'm talking about. What I find around the state is more people get harsher sentences for DUI or leaving the scene of an accident with serious bodily injury than they do with DUI with a death or leaving the scene of an accident with a death. And I guess it's because the victim is in court all mangled up, or whatever the case may be, broken up, and can pull on the heartstrings of the judge, whereas the decedent is not there to defend for themselves, and or there are no family members taking up for them in court. The trial judge may impose a sentence up to and including the statutory maximum for any offense, including an offense that is before the court due to a violation of probation or community control. Synopsis of everything I just said with respect to 921.002, here's the skinny. Number one, equity. Punishment is neutral as pertaining to race, gender, social, economic status. Now, that's the aspirational goal, but in active practice, we don't see that a lot of times, unfortunately, and that's why I'm doing this seminar. Proportionality. Penalties are properly aligned with the nature of the offense. That doesn't always happen, as I just told you. The facts: while sentencing equity is the goal, sentencing inequity and disproportionality, unfortunately, are real issues in criminal justice as follows. And this is across the country. It just happens to be in some states worse than others, and in some jurisdictions within certain states worse than others. Number one, divergent sentences for those who are similarly situated. Number two, greater and or excessive punishment for those with less egregious misconduct. Three, disproportionate punishment that's greatly excessive in relation to the prohibited misconduct. I cannot tell you how many times I've seen that in my practice before I started doing this work right here. As a matter of fact, the reason we're doing this work right now, my business partners and I, you'll see their pictures in a few minutes, is because I had a case that somebody got slammed unjustly back in 2010. And so this system came, that we're going to show you, came from that case. But the facts continue. Florida sentencing history. Now, a lot of people don't know, unfortunately, about the Crime and Justice Institute, study that was commissioned by the Florida legislature to contest the Sarasota Herald Tribune's groundbreaking 2016 study that found massive disproportionate sentencing across the state of Florida. And so the legislature commissioned this study to disprove that study, but in fact, it proved it with more specificity and more credibility. So while the primary purpose of the Criminal Punishment Code is punishment, it was ostensibly devised to achieve the following: fairness, proportionality, and uniformity. The core principles of the CPC are meant to foster sentencing that is unbiased and neutral with respect to race, gender, as well as socioeconomic status. That's a quote right from the law that was quoted by this study. So here's what we have here. This is just one screen from this study. Despite the stated goal of fairness, similar criminal conduct and criminal histories experience vastly different outcomes by judicial circuits. So they highlighted 8 circuits down here. They did a study of score sheets in a certain range, the 22 to 44% range, and then they found a median and an average, and then they put it on a scale and they measured all 20 circuits. And this is the circuit that I'm in right now. So you have the 3rd, the 4th, the 5th, the 7th, the 8th, the 10th, the 14th, and the 19th. Everybody knows about the 19th circuit. So no one was surprised about that one. But it surprised a few others in some certain of the other circuits. But across the state, there is significant variation in rates of prison sentences. 8 of the 20 circuits sent score sheets in the 22 to 44% range to a prison range higher than the statewide average of 11%. And so this is an objective study that you don't know about it because they pretty much buried it after it came out, because it didn't say what I'm quite sure they wanted it to say, unfortunately for them, but fortunately for us. Partial remedy, understanding how to calculate and audit score sheets. In other words, what I'm trying to advocate with this seminar, I'm trying to kill 2 birds with 1 stone, so to speak. Number one, educate attorneys on the significance of auditing score sheets and showing you how to do it, so that when you do it right, you can avoid some of these unnecessary, inequitable sentences. So learning how to do it will operate as a check and a balance on prosecutorial power. It'll guard against the criminally accused being overly charged and thereby excessively punished. You're going to see that in a few minutes on some slides. Protects the integrity of the criminal justice system by fostering trust that sentencing is fair and properly proportional to the charged offenses. Now, you're going to get a survey. If you complete this survey, it's going to have a question, if I remember correctly, that talks about, can this seminar promote or advance public confidence in the criminal justice system? Well, if you can properly score a score sheet and avoid an excessive sentence that otherwise would come because you didn't know how to score it properly, that is going to foster better integrity and confidence in the criminal justice system by those who use it. So contributing issues, the failure to know how to properly score and therefore evaluate criminal punishment code score sheets can, not always will, but it can contribute to inequitable, disproportionate, and or unconstitutional sentences of the criminally accused. The obvious remedy is learning how to be proficient in the score sheet preparation process. And so the Florida Department of Corrections has this manual. You probably never heard of it, but it's available on their website. And you can look at it and it will show you how to actually complete a score sheet. It's long, it's voluminous, but it's worth the time to go over it, because the time that you put in it to learn how to do this properly can save your bar license. It can save your livelihood, because to miscalculate or not look at an improperly calculated score sheet is ineffective assistance of counsel at best. It's malpractice at worst. And the reason it is because a person can receive, and they have received, grossly excessive sentences when, for instance, like 120 points or any points are added that shouldn't be added, and it stretches the sentencing range. And so this Florida statute 921-0023 has the until the legislature specifically assigns an offense to a severity level in the offense severity ranking chart, the severity level is within the following parameters. So on a felony of the 3rd degree, it's a level 1, 2nd degree, level 4, 1st degree, level 7, 1st degree punishable by life, level 9, and a life felony, level 10. Now, each one of those carries certain points, and we're going to get into those momentarily. So how to audit score sheets, the severity ranking chart. The offense severity ranking chart must be used with the Criminal Punishment Code worksheet to compute a sentence score for each felony offender whose offense was committed on or after 1998. Now, listen, when I first started practicing law, we were doing all this by hand. The computers do it. It's computer generated now. However, it's subject to human error, because if a prosecutor, for instance, puts in the wrong level of offense, it's going to have points higher than your client should really be receiving. And so it has to be audited to make sure that they did it properly. Almost every score sheet that I've seen that was was improperly scored haphazardly was against the defendant. Now, I've seen a few that were scored downward, but the prosecutors knew what they were doing. They were trying to give a lawyer a break, so they scored it as a level 7 versus a level 8. Or they didn't add victim injury points when they should have to give the lawyer a break who was negotiating the sentence. The offense severity ranking chart has 10 offense levels ranked from least to severe, which are level 1 offenses, to most severe, which is level 10 offenses, and each felony offense is assigned to a level according to the severity of the offense itself. And you can screenshot this. That's the website to get that information. Now, how to audit score sheets. Let's get into some weeds right now. Let's look at, here's cases that I deal with most of the time, helping lawyers around the whole state of Florida. The death cases and the serious bodily injury cases. Now, this is leaving the scene of a crash involving a serious bodily injury. So that's a level 6 offense that's going to carry so many points. As a matter of fact, level 6 offenses carry 36 points. A level 7 offense. Look, let me back up. I want to show you something. Pay very careful attention to these. This is in the weeds now. 316.0272B is leaving the scene with serious bodily injury. But when you change it to 2C, now it's up a level, set to level 7, accident involving death, failure to stop, leaving the scene. So that one letter kicked it up to a level 7 offense. And I cannot tell you how many times I've seen the letters that are wrong and the offense is higher. I never see it wrong when they're lower. It's always higher. It has to be, corrected. And so I don't know whether some prosecutors, I'm going to give them the benefit of the doubt. I'm not going to accuse anybody of anything, but I don't know whether some of them are doing that accidentally or not, but I've seen it too many times. So that's why I'm doing a seminar on it. Then level 8, now you get into your DUI manslaughter. Let me back up. DUI manslaughter cases. And you also have DUI with serious bodily injury as well. And so when you get into your DUI manslaughter with failure to render aid or give information, now you're kicking it up to level 9. And I had to highlight that Medicaid fraud, provider fraud, 50,000 or more. Definitely need more. Let me be quiet. Let's go to the next screen. How to audit score sheets. Level 10 offenses. Here you got the knowing sale or purchase of controlled contraband, prescription drugs, and charges like that. I think I've only dealt with one case like that for a lawyer so far. So let's get into some more weeds here on the offense levels. Very important screen here. So your level 10 offenses are going to have 116 points. That's points just for the nature of the offense itself. That doesn't count victim injury or any enhancements or anything. And so as you see, each level of offense is carrying these numbers of points right here. Now, again, the prosecutors, when they do these, it's automatic scoring system in their computer. There's a lawyer in Daytona. I can't think of his name. You can look him up, but he created his own automated system to score. Very good system. I looked it up, and I think it's being retweaked now. But he created software that he has accessible online for anybody to use that helps you calculate these things on an automated basis, so you won't have to do it by hand. But it's also good to know how to do it at hand, so when somebody does it on an automated basis, you can check behind them. And so when you have additional offenses, without, with the exception of a couple scenarios, it's basically half of the total number of the original offense. So if I go back, you see a level 10 is 116, level 9, 92, level 8, on 74. And so a lot of times, there are a few exceptions, but it's usually about half of that for the additional offenses. And now, victim injury points, the death points are 280. I'm sorry, the murder. And then the murder is 240. The death is 120. So when you talk about DUI with a death or leaving the scene of an accident, with a death, you're looking at 120 points. And severe injury, 40 points, moderate 18, slight 4, sexual penetration 80, sexual contact 40. Now, let me tell you what I've seen since I've been doing this work with sentences and everything since 2018. I've seen cases whereby it was a sexual battery, penetration, multiple penetration, anal, oral, and vaginal, yet there was scoring, 40 instead of 80. That's to give the lawyer a break who they're negotiating with. In other words, what I'm telling you is that when a prosecutor really wants to give deference, they can just not charge the full 80 points. So if you have a sexual battery slight with no penetration, it's unethical and immoral to charge 80 points. However, if you have a penetration, the prosecutor can charge down and charge just 40 points instead of 80 points, because the sexual contact, every sexual penetration is sexual contact, but not every sexual contact is sexual penetration. We're definitely in the weeds. Okay, so our prior record points for each level of offense, that's a prior record. Here are your points right here for each one. Like I said, all of this stuff is right in the statute. And by the way, I don't know if it's still working, but the Florida Department of Corrections had a score sheet system that they created with the data transparency law in 2018, which is still atrocious. I don't think the thing still works to this day like it was supposed to. But they do have, or they did have, a score sheet calculator on their website, and prosecutors told me that it didn't work right. And I know the state attorney office in Miami, they created their own system of score sheets. 2 years ago, I don't know what the situation is now, but 2 years ago, they were not even using the state system. They had their own. So the last page down here, you got your legal status, community sanction, prior serious felony, all of these enhancements here that you get points for those as well. And so we're going to look at this is an actual score sheet, and these are cases that I worked on with lawyers, helping them get the right sentences. Most of these, well, some of these are somebody who's received an excessive sentence that were improperly scored, and now the lawyer is coming back in to try to get the sentence made right. So I need a bold person. Please don't use the chat because I can't see it right now. Look at this score sheet. There's a problem with it, and see if you can determine what the problem is. There's a critical error on this score sheet. Can anybody figure it out just by looking at it? I mean, if you know this stuff, you see it immediately. There is a glaring issue with this score sheet that if it goes through like this, somebody's going to potentially receive an excessive sentence. Can you see the problem? Anybody, just unmute and tell me right quick if you see it. Then that's good. That means this seminar is necessary. Okay, 5, 4.
It shouldn't be at 120 for the death.
Right. Why not?
Because he's not charged with manslaughter or whatnot. He's charged with leaving the scene of an accident, which is it's a much different charge.
That's correct. That's correct. But now, do you know why it should not be? Everything you just said is correct. I'm just trying to get you in the weeds a little bit more with me. Do you know why they shouldn't have charged that? There was a death in this case. The person did leave the scene, but why can they not legally be charged with that death? Do you know?
I'm guessing
it's already included.
Say again.
Is it because it's already included?
Okay. I heard, okay, one more. I heard a gentleman, but your voice was so low I couldn't hear you. Can you increase your volume and say what you were saying again, please, sir? Heard him. I thought I heard a man. Okay.
No, I was saying because it's I mean, leaving the scene with death is already what Ms. Rojas was saying. It's almost double jeopardy when you're adding the death. It's either going to be double jeopardy because the death is already included in that charge, or he's not charged. It's a involuntary, I believe.
You're all over. You're all over. We're gonna get to it in a minute. You're right there. We're together. We're together. You're right. The point should not have been added. Now look what it did to the score sheet. Let me back up. So you have 56 points here, okay? And then when you add 120 points, now you got 176 points. It stressed that score sheet out tremendously. So this should really be, the total sentence point should be 56, but it's 176. So this is stretching the math all out of the way. So now So that's the problem. So I'm going to show you some case law. Here we go. Defendant appealed the sentence imposed by the circuit court in that county involving the death, personal injuries in violation of this statute. Okay, defendant appealed his sentence, arguing that the trial court erred, scoring the victim injury in determining the recommended range pursuant to the guidelines. The appellate court agreed, reversed the sentence, remanded it. Okay, the appellate court reversed the sentence imposed by the trial court because the death was not charged. The person's not charged with the death. The person is charged with leaving the scene of an accident. And the reason that is because most of the time, a lot of times, not most of the time, but a lot of times, the pedestrian is at fault. A lot of times the person is at fault, but the person who hit them freaks out and they leave. Or like I had a case in my practice years ago, my client, a kid ran out in front of his car and he didn't have enough. He tried to stop and he couldn't, so he hit the kid and killed him. But he was it happened right in front of one of the worst apartment complexes in Jacksonville that's filled with gangs. And so when he stopped to render aid or find out, the people started running and said, "We're going to kill you." So he took off. And so I used the arrest as a defense in that particular case. He was charged with leaving the scene of an accident with a death, but he was not charged with the death. So this case right here basically explains it. There's another case that I have for you as well. And I got these from Bobby Reef down in Fort Lauderdale. He does a lot of DUI manslaughter cases, so he looked these up. Here's another one, Benedict versus State, 475 Southern 2nd 1000. It's a 1985 case. That's a good year. That's the year I graduated from law school. So that's why. Here's the case law on it. So if you have a case with leaving the scene of an accident, and we're talking about 316.0272C. That's the one. Now there's another one, leaving the scene of an accident, failure to render aid, and all that. That's another whole charge. That's an enhancement. You get a level 8 offense for that one. But let's go on here. So, okay, leaving the scene of a crash with a death. Now, here's a score sheet that's proper. You don't see any death points right here. This score sheet was scored properly. Now, unfortunately, this person has a healthy criminal history, but as you see, 56 points for that level 7. He has an additional charge of possession of a controlled substance, so he gets 2.40 for that. Add all that up, 62.10 for that particular person, and worked on this case as well. State prison, 7 years followed by 5 years probation. That was an open plea, and if I remember correctly, I had to testify as an expert witness in this case. Been doing so many, I can't recall all of them, so that might be incorrect. But anyway, here's a leaving the scene of a crash involving death with a vulnerable, vulnerable road user. That's the one that enhances it up. That's an enhancement that kicks it up to level 8. So now you're getting 74 points as opposed to 56 points. I'm right here. And but again, no death points in this particular case because he's not charged with causing the death. He's caused with leaving the scene of the crash. So in other words, if the pedestrian is at fault and you don't stop, you can be charged with a serious offense because you left the scene. And so the charge is to give people an incentive to stop and render aid when the actual, victim caused the crash or the death. And here you're looking at that 4-year minimum mandatory. I think that was a wrong slide right there. I think that slide is out of order. But in this particular, that slide is out of order. So in this particular case, this person got a 20-year sentence. And that should be followed by 10 years probation. The probation should be checked. That's a failure on the score sheet part right there, because that is on the probation line. Let me show you something that a lot of people don't know, and it's critical. If you put a figure on the wrong box down here, it will void the score sheet. For instance, if this 20, no, that's not a good example. But let's say, for instance, you put 465 days on this line right here, 465 days. Or if you check off county jail, check off county jail and put 465 days right here, it'll void that score sheet because it's only 365 days in a year, and you cannot get over a year for a county jail sentence. So that score sheet will be voided, and it will be rejected by the Florida Department of Corrections, sent back to the clerk's office for the clerk to send it back to the prosecutor's office to correct that score sheet. I hated to get into the weeds with you on that, but that's important to us because we have to have the data properly input in the system in order to use it with our system. So let's quickly look at a vehicular homicide case, which is a level 8 offense and 74 points. And here, as you can see, they properly charge, they properly score 120 for the death because the death is charged. They also have severe injury, 2 people, so that's 2 times 40, that's 80. So that's an additional 200 points on top of the 74 for those deaths, that death and those injuries. And so here's the calculation on it. The maximum a person is facing is 50 years. Lowest permissible sentence, 207.3, divided by, excuse me, your months, and that'll tell you what that is. And this score sheet was still being worked on, so the sentence hadn't been given out at that point. Okay, so let's look at DUI manslaughter. And so you have 316.193 C3 DUI manslaughter, 74 points. The death was caused by that drunk driver, and so the points are properly assessed. And so you have the 74 plus the 120 for the 194. I think this case I did work on, and we did get a downward departure. And the offense was committed in an unsophisticated manner and was an isolated incident for which the defendant has shown remorse. Like I said before, this is not an exhaustive list. So if you have a basis that you feel is rational, that you can argue for a downward departure, use as many of these as you can, okay? But if you don't have any, argue equity and proportionality, because there are a lot of cases that you can use to back that up. And so that's what we do with lawyers. We give them the cases. So in this particular case, the state prison looked at that 8 years followed by 7 years probation, mitigated departure. And what we recommend is that the judge, the lawyer draft an order, explaining all the dynamics of the mitigated departure, and it won't be overturned on appeal. Now, if you just check off mitigated departure, it's going to be reversed for a sentencing de novo, and you won't have another chance to do it. In this particular case, we provided data to the lawyer. This was a public defender, by the way, in Escambia County who used the system. And my services as an expert witness, I testified before a judge in this case. And it just so happened that we hit the jackpot. And several of these cases were cases that the particular judge who was handling the case had decided. So it's very difficult for her to do what the state was asking, because the state was asking the judge to sentence this person excessively, and the judge had never sentenced anybody to that amount of time. So when the judge saw the cases that she had sentenced other people on, as well as her colleagues in the jurisdiction, in the circuit, in the county, that sentence was given out. So you want to do what's called a motion for the court to take judicial notice of the records. You don't need a certified copy if those records are right from your clerk's office, and that's the data that we use in our system. So deploying technology as the remedy, the imperative question becomes, is there any means to ameliorate these unfortunate situations? And there is. So what is ESAS? What is the Equity in Sentencing Analysis System? It's inquiry, reporting, and statistical analysis software that can quickly, and I do mean quickly, analyze, compare, and contrast sentencing data as follows. Number 1, statutory charges, score sheet points, offense date, sentencing type, sentencing date, sentencing judge, minimum maximum sentencing range, defendant's name, race, gender, date of birth, defendant's age at sentencing, the case or docket number, so you can look up the case yourself in the clerk's office to get a score sheet to append with your motions and everything as an exhibit. ESAS reformats existing criminal history data to craft equitable sentences by comparing and contrasting, that's the analysis, prior sentences of similarly situated persons. This exercise is performed at a mouse click with the results in a few seconds, depending on your internet speed. Okay, what is ESAS? What is it not? Although ESAS is information derived from the Department of Corrections Criminal Punishment Code score sheet data, it is not an official record of the court. Let me just say this right here. The trajectory of the data is this. The state attorney completes it. So right there, if there's an error, it's on the state's part. So a lot of times I'm having fun when I'm getting cross-examined because they're trying to hammer me on the quality of the data. I just kind of politely say, well, the origin of the data is your office. So if there's anything wrong with it, your office is the problem. So anyway, when they hear that, they kind of back off. So the prosecutor completes it, gives it to the clerk gives it to the judge signs it, gives it back to the clerk submits it. I think most clerk's offices submits it like once a week, some once a month. It is electronically transferred to DOC, and then DOC massages that information and puts it in a database that we get once a year. So our system has over 2 million records in it, but the origin of it is each respective clerks of court. We just get all of it at once from the Department of Corrections. If necessary, copies of official record, score sheet data, and other case information can be gotten from the clerk. We've been doing this work since 2018, and I've only had one lawyer who needed a certified copy, and he was using this data in federal court. So he got certified copies of the state sentencing score sheets to file in his federal case. So here are some of the column definitions that you're going to see when I do a demo in just a few minutes. Statute number, this is the data that we have, the statute number, statute description, and it pretty much tracks the Florida statutes, the offense level, the points, the sentence type. SP will be state prison, CJ county jail, CC community control, PB probation, TS time served. If you see this right here, you're looking at a sentence from a violation of probation case where the person got reinstated on supervision. Or if there's some kind of funky or unique sentence, like, go stand on the corner with a sign saying I'll steal no more, that won't be in the score sheet. So they'll put other down there. Sentence years, minimum, maximum sentence in years, maximum. The disposition plea, trial, or NS. If you see NS or NKWN, that means it's unknown because the prosecutor again failed to put the disposition type. And you know how it works when they complete a score sheet and give it to you at arraignment. Okay, that case might last 6 months. Well, if it goes to trial and then they finish the score sheet, if they forget to check off trial, it's sent in with that blank. Or if it works out in a plea bargain, they forget to check plea, it goes to Florida Department of Corrections blank. They'll just leave it blank. So what we'll do is we'll put NS or unknown. That lets you know that the state attorney office failed to complete that box. Minimum mandatory sentence if there's one given. Case or docket number, last name, first name, race, sex, date of birth, age at sentencing. All this information you're going to see in a few minutes when I do this demo. So ESAS is a service of technologies for justice. And here are the partners and myself, Chris Parker, who's on with us. I don't know if Buster's on, but Buster is the brainchild of this data, this system that you are going to see. He's the one that actually facilitated all of this work, this marvelous work that you're going to see in just a few minutes when we do a live. So what I'm going to do is I might have to do a screen share, so you're going to have to let me know. I'm going to try to go in to ESAS. Give me 1 second. Might have to do another screen share. Hold on. Yeah, try to do another screen share and get into it. All right. I tell you what, let's do this. Come out of here. That's why I like to record these. Because sometimes the system is quirky. Okay, let me try to go in here. All right, got to do something different. All right, Go. Stop share. Just give me a second. So okay, I think that'll do it right there. Now, let me know if your screen changed to ESAS. You should have it up now or in a second. Let me know if you have it. You see equity and sentencing analysis system?
Yes, I see it.
Yes.
Perfect. Okay, good. All right, so I'm going to go into ESAS, and it says, I hereby acknowledge the equity and sentencing analysis system is a research and reporting tool. ESAS data is derived from public records and is not official records. The accuracy of the data displayed should be verified with the clerk of the court of the respective county that generated the case numbers, copies of official records, blase, blase. So once you get that acknowledgement, you click proceed. And so you have search options, defendant's name, statute number, docket number. Here are the offense levels. We're going to let that default. You can search by the offense levels if you want. Offense range, January 1st, 1998 through right now, June 30th, 2023. That's 2 million records. And it's June 30th because we get data from DOC once a year on a fiscal year basis. So we won't get the latest data until the end of this year. I have access to all 20 circuits and all 67 counties on my application. So if I want to search all, I hit all. If I want to search just for one particular circuit, which I'm going to do, Jacksonville, which includes Clay, Duval, and Nassau counties. It's going to go through. So what I'm going to do is go through 316 027. And I'm just going to put in 120 points in both boxes. That's an apple and an orange and an orange. Now, nothing should come up if score sheets were scored properly because you shouldn't get any death points. Those are death points in these cases. So if something comes up, it's going to be a first offense, leaving the scene of an accident with death, nothing else, no prior history points, no enhancements, nothing else. And so let's see what comes up out of Jacksonville. There's one case of all the cases, and that really, yeah, okay, so that's one case. So let's go back to the search. Now, I'm going to do a statewide search. I'm going to search all 20 circuits, all 67 counties for this statute at 120 points. And we're going to see how many cases. 1 second, let's go back. I think sometime you have to put 02. Let's do 02 first. Okay, all right. Sometimes you have to play around with the digits. Okay, it's only coming out 1. Interesting. Okay, now let's do this. All right. 56 points. I tell you what, let me do something else. I'm going to go from 120 to 9999. That's going to pull up a lot of data. Okay, that pulled up 350 cases, 350 cases. Now, I'm looking for only 316.027 2C. So I'm going to keep that 27 right there. But I'm looking for 2C only. So when I filter that, now, once I click OK, this number here is going to be changed down here at the bottom. It's going to go from 350 to something else down here at the bottom, your bottom right. So once I click this, that took it from 350 cases down to 139 cases, excuse me. So now I'm only looking for level 7 cases. I don't want to look at any enhancements. So I'm going to deselect everything here. I'm going to go with level 7 only, and that's going to reduce those cases again. So now I'm down to 109 cases statewide. Now I want to sort the points and see what the points are. And so I'm looking at these cases right here. These are the points. So you have the statute, the offense level, the CPC points. You have the sentence type, the sentence years, the minimum sentence facing, maximum, the disposition type, plea or trial. There are some trials, and I'm quite sure. We have several different pages of data, as you see. So you have the sentencing date, the docket, the county, the statute description, And you can also sort by the statute description itself as well. That's just another way to sort. You have age at sentencing. You have the race, sex, date of birth, offense date, minimum mandatory. As you see, that's a firearm. That's the other minimum mandatory. You have the judge's names here, the defendant's names, first name and last name and first name right there. So now, let's look at, oh yeah, when this box is lit up, it means it's a split sentence. So if you hover your cursor over it, that's 2 years state prison, 10 years, followed by 10 years probation. That is county jail, 6 months, 2 years community control, followed by 8 years probation. That is 4.5 years state prison, followed by 5 years probation. That is 6 months county jail, followed by 4 years probation. These are on death cases, primarily probably because the victim was at fault. So now you have downward departures are lit up right here. So what's a downward departure? A downward departure will be a number in this box, the sentence that's less than the minimum under the CPC. So the sentence is 2.0, but the minimum should have been 5.8. And so as you see, this is not a downward departure because 10 is greater than 6.5. So since 1.5 is less than 9, that's a downward departure. And so that's basically how the system works. So let's look at trials only. I'm going to deselect everything, look at the trials only. So that took us down to 9 items. So from this date range, from October 1st, 1998 through June 30th, 2023, with this particular charge at these particular points, you've only had 9 trials in all of this time. And so let's sort the sentence dates here. So that runs from 2016 to 2022. So some of these are relatively new cases. Let's say we want to do some statistical analysis on this. I might have to do another screen share. So let me know if your screen does not change. Right now I'm looking at some, yeah, I think I'm gonna have to do another screen share. Did your screen change or not?
My screen is blank.
Okay, that means I have to do another screen share. And unfortunately, we're running out of time. So let me do this right here. I don't want to do that. Come back in here. I hope I didn't. Okay. Let me stop the screen share. Okay, sorry about that. Go back to where I was. Try to get back there. Okay. Go back to the PowerPoint. All right. So we're back to the PowerPoint. Now you should have the PowerPoint back up on your side. If not, let me know, but you should be looking at the PowerPoint. You have the PowerPoint up. Do you see ABA criminal justice standards on your screen? Yes or no?
Yes.
All right. So now here's that sleeper I was telling y'all about, the criminal justice standards. And the standards, by the way, are aspirational. They're suggestive, but they can be dangerous. I'm going to show you how. If a jurisdiction, or like, for instance, if the Florida bar has not adopted this rule and somebody is accused of doing what it says, the Florida bar can adopt it specifically to punish a lawyer for not doing this because it's aspirational. So ABA sentencing standards, criminal justice sentencing standards for the defense 4-8.3. You can look this up online. Defense counsel's preparation before sentencing should, because this is aspirational. Learning the court's practices and sentencing, exercising sentencing discretion. The collateral consequences of different sentences. How will you do that unless you have data? The data helps you do it. So hold on 1 second. I'm gonna play a video for you. The normal pattern of sentences, not a video, but an audio. The normal pattern of sentences for the offenses involved, including any guidelines applicable for either sentencing and where applicable parole. It's not applicable in Florida. The consequences, including reasonably foreseeable collateral consequences of potential dispositions, should be explained fully by defense counsel. Now, here's an attorney who I asked that she go over the data with her client. So if you can't hear this.
Did you go over the data with your client?
I did. I went over the data with him because, like I said, we were planning on, I thought we were going to have to use it as an open plea. So we did discuss it, and like we were looking at him going to prison for anything less than 4 years.
Okay.
But we did go over it, and it was helpful for him to understand what we were looking for.
Okay. And was he going to give you authorization to enter that open plea if y'all had not resolved it by plea bargain?
Yes, he was.
Do you think that that data helped him make that decision?
I think it did. Yeah, I definitely think it did, because you look at the score sheet, and he scored more than the statutory maximum. And I think that's something that helped him see that there's a chance that I may not get, a significant amount of prison time.
So what this does, the system, ESAS, the data, it can not only can it help with plea bargaining with prosecutors. I've seen situations whereby prosecutors trying to get somebody 10 years until the defense attorney pulled up data in court and showed them, look, the average sentence for this, possession of a firearm by a convicted felon in your office in this particular circuit is 18 months. So why are you trying to give my client 10 years? You know what, you're right. We'll give him 18 months. It was over just that quick. So judges, it works on judges, especially the ones who've had other cases that are a lot lower than what the prosecutor is arguing. But it also works quite well with clients who have unrealistic expectations, and you can show them what the average sentences are that have been given out in the jurisdiction, and the plea bargain that you just so happen to work out is a lot better than they thought. Objectively a lot better than they thought. Okay, so ESAS is endorsed by the Florida Bar and officially endorsed by the Florida Bar and FACTO, Florida Association of Criminal Defense Lawyers. Florida Bar lawyers get a 10% discount on the data itself. That's the actual data that we run. We call it a custom search. And FACTO members get an extra 5% for a total of 15%. I wanted to do that because I came up doing criminal defense and I was a public defender, and I know how challenging it is for defense lawyers, even the ones who work in private practice, to get real good help for their clients. So I increased it for the criminal defense lawyers. So subscription prices, we give 3 circuits for $1,100, but you get a 10% discount. Florida Bar members and FACTO members get a 15% discount. You can pay all that at once, so you can do it on a monthly basis by auto debit credit or ACH. If you want all 20 circuits, which some lawyers do, because we have some lawyers who practice in multiple, jurisdictions, have offices in multiple cities, and so that's all 20 circuits, less your respective discounts. And custom searches, I run that data personally. That's $1,500 less your 10 or 15% discount. And now the expert witness work, those are not subject to discounts. And so report, and that's a narrative report explaining the data. It explains the history of the CPC, some of the information I shared with you earlier about why the punishment code came after the guidelines, and how important it is for equity and proportionality to be meted out in sentences. And a lot of judges love that because it gives them an objective basis to do what they want to do. So some judges really want to sentence more equitably, but they feel that they don't have an objective basis to do it. So ESAS can do that. We also do expert witness testimony, remote online, that is $1,500. If I have to come to you, that's custom pricing. Okay, and here's my information. You can take a screenshot of that. I do the expert witness work through my law office, and I am also I have a contract with the state of Florida, to do indigent work. So I do work for lawyers who are on a contract basis, as well as public defender offices as well as anybody who has have a contract with JAC, so I can help the indigent. And those prices, we do adjust those as well. I charge based upon the statutory fee schedule that is established by JAC. So those charges are based on that. And like I said, all 67 counties, all 20 circuits. So if you go on JAC's website and you look up experts, look under other, and my information will be there. All right. So now, fortunately, we have about 6 minutes left. And so this is Q&A time right now. If you have any questions, and this is the basic survey, and it's electronic, but also it's also anonymous. So once if you get it and you click the link, you fill it out, it might take you less than 3 minutes really to do this. It takes less than 5 minutes for sure. And we would greatly appreciate, we like the feedback so I can make adjustments for future seminars. Please do that. And in order to get your CLE credit, you need to send me an email that confirming that. You can do that now. Send me an email confirming that you watched the whole, seminar, and I will send you the course number so you can go ahead on and get that out of the way today or tomorrow at the latest. So I'm going to come out of this, take a screenshot if you need it right now of anything, that email, because I'm getting ready to come out and do some question and answers if we have, and observations if we have any. Okay. 1 second here. Come out of this. Okay, stop screen share. All right, so I'm back now. Thank you all for joining me today. And do I have any questions that I can answer for anybody? No questions either. I must have done a lousy job. No questions, not one. Okay. All right. Going once. Going twice. No questions? All right. I really appreciate you all joining us. And if I can ever be a we, Technologies for Justice, if we can be of any service to you, give me an email, give me a call. And if necessary, sometimes we adjust prices for people who have exigent circumstances or, dire circumstances, or whatever. The objective is to facilitate as many equitable sentences as possible. Hey, Chris, do you have anything you want to say before we end? We got 3 minutes left. Chris Parker, you want to say anything before we go? I'd like to ask, I saw a lot of public defenders from the 17th Circuit registering over the last couple of days. Are any of you all from the 17th Circuit PD's office, Fort Lauderdale? Anybody? Okay. Well, listen.
Yes, sorry.
No problem. I just want to share this with you. Your office is one, well, let me see. Your office is one of the ones that we were really trying to make headway years ago. I really wanted to do some things down there, because I know a lot of people in South Florida. We do a lot of, things in a lot of different offices, and that's one that I really wanted to work with, but unfortunately it didn't work out. But that offer is still open, so you can certainly let your boss know. And I would like to send you a video, a very brief video that shows some of the successes, some of the major successes that this software has been able to bring into fruition for people. Some of them were facing, one guy was facing over 1,000 years in prison, and we got him a sentence based upon the data, about 12 years, which was unbelievable. And so the offers don't go up when this system is used. Now there's one exception. I had a case, for instance, I testified in Lee County several months back, And the judge just gave us everything we wanted. And now the same lawyer has another case, a different case, and they just loaded this client up. And we know that what they're trying to do is play catch up for the other case. But they've hired me already, so I'm going to go back down there and testify again in another case. And the problem with the state is that the judge loves this data. He even told the state attorney, the prosecutor, and myself that he's very, very pleased with the work that Technologies for Justice is doing. So with that one exception, that's the only time I've heard somebody, trying to be harder on somebody because they use the system. But I think once we go down there and do it again, I think that problem may be resolved. So anyway, I think we are just about out of time. It's like maybe 1 minute left. Is there anything anybody want to say before we end this meeting? Please, ma'am and sirs, complete that survey.
1,000 people are dedicated.
Hello, Mr. Barlow. Is it
Yes.
possible to share your email address or other contact information, social media, or anything like that?
Also learn more on
Okay, yeah, I'll just tell you my email address is technologiesforjustice@gmail.com. technologiesforjustice@gmail.com. Let me put it back up there.
our staff proudly take care of our
So
people,
you can.
but also each other in our local
I'm trying to share the screen
Our
again.
staff will donate countless
Let me know if
hours
it's up there. It should be technologiesforjustice@gmail.com.
May I also inquire as to the CLE number? I apologize for chiming in.
Yeah, what I'm going to do is, like I said, send me an email at that address. You send it to me right now. I'll send it to you in about 10 minutes. Send me an email. Just let me know. I watched the seminar today and I need the CLE number. I'm going to email it. I don't want to leave it. We're recording this. I don't want to leave it on the recorder because, unfortunately, some people, they'll just get it.
You don't need to explain it. I think we all understand the why.
So that's why. So
Okay,
anyway,
are you going to send a group email to
No.
everybody who registered? So we need to email you directly.
correct.
Roger
You
that.
can register.
Okay, thank
you can register and have it on and be drinking coffee somewhere downstairs. So yeah, just send me an email and I'll get them right out. Like I'll send
Roger
them
that.
right
Thank
out.
you. Thank you again.
All right, y'all have a blessed day.
Thank you, Mr. Barlow. Enjoy the rest of your day.
You're welcome.
Thank you.